Hello guys, and welcome to another episode of my lecture. On today's episode, we'll be talking about oppression as a tool to determine whether or not it should be admissible or it should be rejected or expunged from a particular proceeding. And so at this point, let's go to my notes. Now, the first place we need to start from is section 29 subsection 2a. Now, it says that if in any proceeding where the prosecution proposes to give in evidence a confession made by a defendant, it is requested to the court that the confession was or may be obtained A. by oppression of the person who made it. Now, we are saying that when they want to tender a confessional statement into evidence, A is telling us that where that confession is gotten by oppression, then we'll read the concluding part of B, the court may exclude it from evidence. Now, we then need to define what exactly then would be oppression. We then go to section 29 subsection 5. It says in this section, that's section 29, oppression includes torture, inhuman or degrading treatment, and the use or threat of violence. That means you either use violence or the use of threats of violence, whether or not amounting to torture. Do you understand that? Also, we have to look at the case of SACHS JR versus PRIESTLEY. Oppression imports something which tends to sap and accept that free will which must exist before a confession is voluntary. Whether or not there is oppression in an individual case depends upon many elements. These include things like the length of time intervening between periods of questioning, whether or not the accused has been given proper refreshment or not, and the characteristics of this person may be salient. The principle of oppression was applied in the case of State versus OLOYEDE. The accused has undergone interrogation at different times for 7 days. He had been kept in solitary custody, during which no attention was paid to his failing health. He was weak both physically and mentally. He was rushed to the hospital because of ill health. Agbaje J had no difficulty in holding that the statement made by him under such bad state of health was involuntary and therefore inadmissible, as same was made as a result of oppressive conduct. So this explains exactly what I was discussing about in my last lecture, where I told you that when we are talking about oppression, if we look at that case, the Priestley's case, the court held that oppression is that thing that has sapped the free will out of the confessional statement. Do you understand? Oppression could be, it depends on every case. We have to look at the element of each case before we can determine what oppression is, because we have to look at the health of the person. We have to look at, for example, if the person has ulcer. Now, when you don't give a person food for 3 days, a person can withstand it and still be in a normal mental state to either answer questions and all of that. You know, we have MFM people who pray a lot and who go to the mountain, and 21 days is little for some people. But you see people like us, like this, that we like food. Once it's 24 hours and we have not seen food, anything can make me sign anything. Do you understand? So for those kind of people, we have to look at their state, and also more importantly, we also need to look at whether or not the person is an ulcer patient. So if you have ulcer patients who need to eat as much as possible, in very little time. Now, when you have those kind of people and that person wasn't giving food in 2 weeks, in 3 weeks, you can imagine the discomfort that person would feel and how much that person might want to sign a confessional statement. So you will see that you can also look at certain things. Even the cell, if the cell is in such a state that could be mentally torturing, or maybe there are inmates in the cell who are torturing the particular individuals, if that can be proved in court, it can also be proved that the confessional statement that came as a result of that particular ill treatment, even though not by the police but by the circumstances where they have kept the accused, if you can prove that those circumstances are such that would then be regarded as oppression, the court is more likely or more inclined to not admit that particular confessional statement into evidence. Do you understand? Oppression can be seen under section 29 subsection 2a of the Evidence Act, which is defined under section 29 subsection 5 to mean torture, inhuman or degrading treatment. Inhuman and degrading has also been defined constitutionally to mean, a lot of things. A slap, cutting the person's hair, humiliating the person, those kind of things that might make the person give in to the confessional statement. Those are the things that the court, will look into account when defining, what oppression is. And also, the latter part of section 29, subsection 5, relating to the use or threat of violence. That is, whether or not there have been actual use of violence, or whether or not there have been threat of violence, whether or not it amounts to torture. Those are the things that the court will look at when talking about the admissibility of a confessional statement on oppression. But we need to look at what exactly would determine threats, what exactly would determine torture, what exactly would determine the use of violence under this particular section. And that's what we'll be talking about in my next lecture. I'll see you in my next lecture.